8 cases, correct? Everybody
Yes, sir.
is called or are called. Eight cases are called, but I've got cause number 21-37686. Refresh my memory. Did the defendant plead guilty to one case?
Yes, sir. And the rest
And
will be dismissed.
All 7 others are to be dismissed today.
Yes, sir.
Everybody, okay, and yes, I've got on 21-37868. Are both of you on this one, or
No,
is
sir.
it just Miss Mantle?
Mr. Lane is on,
I got it.
19.
Judges 37868. I just wanted to on that. That's going to be Ms. Mantalini.
Yes,
But
sir.
you're here because the other cases are going to be wrapped up at the same time.
Yes, sir.
And in the event there's an issue, you're in the bullpen.
That's correct.
He's only on one other case, one of the cases. But yes,
Really?
the oldest case.
I've got, actually,
Well, I think it's, if it says that, it's an error because I'm on all the cases except one.
okay. You're on 33660, and that's going to be dismissed, correct, Kevin? And the others are going to be dismissed, save for 21-37868. And 37868. And the other, all other cases, which are 22-40125, 22-40124, 21-37872, 21-37871, 21-37870, 21-37869, and finally 21-37868 for all called the state of Texas versus Kendrick Deshaun Bailey, and that is you, sir.
Yes, sir.
All right, you're present with Ms. Mantalini, Mr. Lane. You have pleaded guilty earlier in this case in cause number 21-37868, which is the last case in this order on the docket. And this is the first degree felony of injury to a child.
Not the one that's referred to.
What'd you say?
Just count one is what we're proceeding with.
Which is what?
The injury to a child, first degree felony.
It's charged in
Hold on.
alternates.
Okay, you're talking, when you say count one paragraph, there's a,
1 and 2.
there's 3. What appears to be actually 3 paragraphs, but paragraph 1 is entitled, the second paragraph seems to be called paragraph 1. So the first 2 paragraphs, including paragraph 1, constitute the first degree felony of injury to a child. And paragraph 2 is a second method of committing the crime, which is not pursued.
Yes.
Correct, Judge. That would be it's reckless, and that would be a 3rd degree.
No, that's, it says intentionally and knowingly causing bodily injury in paragraph 2.
What does the paragraph, second paragraph say? It's just, oh, it's serious bodily and bodily. That's the difference.
Mhm.
Same thing. First degree and 3rd degree.
Proceeding on the first degree rather than third degree.
All right, so in summary, Mr. Bailey has earlier entered a plea in indictment, the first paragraph and the second paragraph entitled paragraph 1, together constituting a single count of the first degree felony of injury to a child, in summary, on or about November 13th, 2019 in Jefferson County, Texas. It is alleged, for which you have pleaded guilty to, that you intentionally and knowingly caused serious bodily injury to a child not older than 14 years of age. Do you understand, and are you reconfirming that is indeed what you have earlier pleaded guilty to, sir?
Yes, sir.
And of course, we talked about it. That was a first degree felony. Can I get the pad and pull that up to make sure that all of that was done in order? Thanks. So this is a regular first degree felony punishment of no less than 5 nor more than 99 years confinement or life imprisonment and a fine up to $10,000, correct?
Correct.
An agreement was reached in this case, and it looks like this was on 6/24.
Yes, sir.
An agreement has been reached in this case where whatever sentence shall not exceed a cap of 25 years imprisonment. So is regular probation an option in this case? Everybody agrees it's not, correct? Because of the nature of the charge. So
Deferred probation is.
okay, what else was I gonna say?
I know exactly what you're gonna
Yeah,
say. but-
but you're right. You can, first of all, you could be found guilty and sentenced to no less than 5 nor more than 25 years imprisonment. Yes, sir. The other option I think that's only available is you could, any finding of guilt can be deferred by me. You could be placed on deferred or unadjudicated probation for up to 10 years in length. There is no fine attached to this, I guess. And from the state, you can see I highlight all this stuff, but I wanted to ask you, is there any restitution here?
No,
It would
sir.
seem like there would be, but I don't see any hint of it.
None that I would characterize as calculable.
A pre-sentence report has, while we're waiting, a pre-sentence report has been prepared by the probation office for Jefferson County. Have the parties had an opportunity to review it? And are there any objections or changes to it? State, and then I'm sure the defense may have some things. Anything from the state?
Judge, no objections or changes, but I would like to supplement it with some photographs of the injuries involved. I've got
Okay, have you
17.
Have you
Yes, but-
tendered those to the defense?
I've seen, whatever he's got, I'm sure I've seen already, but through all the discovery and when we were preparing for trial. I would say, before he tenders those or the judge accepts them, that the pre-sentence report is riddled with all sorts of extraneous offense information.
We'll talk about it.
And I would ask that, well, those pictures also refer to extraneous offense information. I would ask the court to not include extraneous offense information in determining his sentence for
But
this.
is that information wrapped up and relevant to the crime for which he has pleaded guilty to?
I guess if we were in trial, it would have all, maybe, most of it would have been able to be admissible in certain parts
I think,
of it.
I think at the time of sentencing, isn't it pretty, as long as it's relevant and reliable, it's admissible because it goes toward what the analysis of determining a sentence is in any criminal case, and that is criminal history and the circumstances of the crime and the relevant matters that directly relate to the character of the defendant. It's global. It's always been global. As long as it's relevant and reliable, and everything is relevant when the court is setting a determination of what the punishment should be.
And Judge, I'll note that the PSI, when they're referring to extraneous offense information, it's pertaining to extraneous offense information involving the same child. The PSI does not have other extraneous involving other children, which I did.
Well, hold on. That's not, again, well, I may have interrupted you there, but it really doesn't matter. It's important for the child, but in this case, it's got to be something that was directly attributed to his actions.
Right. And that's what I mean is his actions involving the same
Because
child.
if the child's harmed by somebody else,
No,
I'm
that's
not
not what we're,
punishing him for that.
that's not what we're referring to, Judge.
And and I guess. No, I would like to, I know that we're at the very beginning of this hearing, Judge, and what I want to preface this hearing with is as I'm here advocating for him, for Mr. Bailey on this sentencing, he doesn't feed me my words and he doesn't tell me what to say. And so the things that that I may say or bring up are not intended in any way to have the court want to believe that Mr. Bailey is not taking responsibility for what he pled guilty to, which he pled guilty to injuring the abdomen of this child and it caused some intestinal swelling. And that at the time, it was apparently it rose to the level of serious bodily injury. There are all these other allegations that are made that were not litigated and that are going to be dismissed. And those are the things that I'm,
Point those
pointing
out, if they're included in the pre-sentence report,
Yes.
and he didn't plead guilty to that unless the state is going to independently produce evidence to show them beyond a reasonable doubt, then I'm not going to consider them.
And so that's also going to go to some of these photographs that are about other allegations that he's been indicted for that are going to be dismissed.
Has to be proven to me beyond a reasonable doubt.
So any of those items I would object to, but any other, there are also comments, and I think the stage we're at right now is you're asking if there are any other objections or changes to the pre-sentence report. So in my, the long time that I've been doing this job, the pre-sentence investigation report, it has the police court version. There's really not much we can object to because that's their version. We don't have a right to challenge their version. But there are things that are mentioned in their version that are also mentioned within the body of the report. And so that are incorrect statements. And I don't want to waive any objection or have something at a later point in this hearing be said, well, you didn't say anything about that in the beginning. So there are numerous things that I would need to point out as being either incorrect statements. Some of them are just based upon some of the things that were in the records. And so I don't know how to quite cover myself and Mr. Bailey on things that are that need to be objected to, but are corrected. I need to see what kind of leeway you can give me there so that I'm not having to go line by line and not objecting to something in the police court version that also appears later on in the body and having waived any objection. So I would, I'm really not sure how to proceed with that issue.
You go through it and tell me, that's the
Okay.
best way to do it. Is you go
All right.
through the pre-sentence report and tell me what you feel like is
Not correct.
objectionable, and then we shall deal with it. Finally, the computer program is back up.
Good.
And here, earlier, the defendant, as we say, pleaded guilty to the first degree of felony, and that the plea agreement showed whatever sentence shall not exceed a cap of 25 years in prison, and also several other cases will be dismissed. It looks like it says state will dismiss. I don't understand this. Can you help me out on that? See, there's a dismissal and then there's a one concurrently. There's
Well-
only two on the dismissal line, but I think I've got a whole bunch of these that aren't all these gonna be dismissed?
Judge, I
Well, that's
don't
not
think that
included.
all those would have fit on that dismissal line,
Yeah,
but they're intended to be there.
But is anything running concurrently?
It just, Judge, there's only one first degree charge, and that's what
Is
he's pled to.
Is this running concurrently with anything else?
No.
Okay, well, let's take out the word concurrently on this, so, okay, I'm just marking through that. So you've got, we'll dismiss 1, 2, 3, 4, 5, 6, 7, 8 cases.
Yes, sir.
There's 9 total.
Let me see, there's
think
1,
so.
2, 3, 4, 5, 6, 7, there's 8 total. We've pled on 6, 8, and the rest will be dismissed.
But I've got 1, 2, 3, 4, 5, 6, 7, 8.
May I see yours? I'm sure I'm the one that had to fill it out. And let me correct any thing that, by the time I got to the 8th set, I'm sure it's not hard to believe that an error might have been made. So
It's
there's
showing 8 sets of
71,
case numbers
72,
to be
24,
dismissed.
7. Oh, there, 40125 is on there twice by accident.
Is that right?
There's Kevin's.
Here, let me, okay,
Right.
is that all there is?
I think that.
That's
was on
duplicative?
twice.
Okay,
Yes, sir.
then,
These are all your case numbers.
all right, I think, here, look at this, everybody.
Kevin. 69, 70, 71, 72, 24.
Here, and just initial it.
sir.
Please. That's right. Okay. That's. All right. The other thing is, I'm not showing any of those dismissals in the queue.
I'll be submitting them today, Judge.
You're doing, okay. They will be dismissed today.
I've got the
So I
tablet.
will order them to be dismissed as part of this agreement. All right, the pre-sentence report has been prepared. The parties had an opportunity to review it. Are there any changes or corrections, first of all, from the state?
I have 17 photo exhibits, representative photo exhibits that we're asking to supplement the PSI.
All right, but any corrections or changes to this paperwork?
No, sir.
We'll deal with that in a little bit.
Okay, Your Honor. On the first page of the pre-sentence report in the police court version, what is being reflected throughout is basically, I believe, an interpretation of, and some absolute recitations of what's found in the reports and everything that ultimately may or may not have been exactly accurate. I don't see that would be something I would object to at that version. For example, down at the bottom, there's the last sentence, next to the last sentence, Bailey continued to live in the apartment. That is also mentioned later on in the pre-sentence report, and I would suggest that having that in this portion of the pre-sentence report is just reflecting the reports that were in the case, but I will be addressing that is not correct in the body of this pre-sentence report that he did not live there. Okay, so that to me would be an incorrect statement.
Okay,
But at that point, it's just based on the records at that point. The
Anything else on the first page?
I'm working on it. Just give me a second, please. And again, in the first page, in the first paragraph, it mentions there were suggestions based upon the blood work that there were suggesting liver failure and signs of pancreatic failure. He's here on an abdomen issue, and it also turns out that in the medical reports, it was determined that there was no failure, no indication of failure of any organs. So although that was in the original reports, it is later determined in the medical reports that that was not a correct finding at the time, or comment at the time. Different people were making that comment, but it's not supported in the records. But the fear of it was, but the ultimate results, it is not. Again, in the police court version, it's riddled with extraneous offense information that's not been litigated and is going to be dismissed, and I would ask the court to disregard anything other than his injury to the child's abdomen, which is what he has pled guilty to and is part of this plea agreement. Defendant's version. I would move to the juvenile court history. It's not so much a objection, but it is a little bit of clarification. I went over that with Mr. Bailey on page 3. And those things that occurred in 2008 and 2009, the first two listed there for the possessions of a controlled substance and dangerous drug. He's a little confused about, back then he was 15. How old are you now? 31, who was 15, and he is not challenging the information, but he's just a little fuzzy on exactly what he was on the probation for. He just knows that he did get in trouble in Harris County. He did his probation in Jefferson County. That's the main thing that he remembers from that. So he's not saying that it's not true. He just didn't remember being on more than one probation, but he's not saying he wasn't. It's just not real clear on it. And then and as far as the deferred prosecutions, he's not objecting to those. He knows he did get in trouble in Harris County on that last entry as a juvenile for evading detention, but he came back to Jefferson County. He was told to leave Harris County basically, and he doesn't remember having to serve anything or do anything special under that deferred prosecution, but he's not saying it didn't exist. On page 5 at the bottom, it discusses a CPS safety plan explicitly prohibiting his contact with the children. The CPS safety plan did prohibit his contact with the children, but it was a plan that was only made with Jennifer Lopez. He was not a party to that. They didn't discuss it with him. He didn't sign anything. He's never served with anything. It was a plan that she agreed to, but he is nowhere a party to that. And you'll see represented several times how he blatantly just refused to follow the orders under this plan, but he was under no orders in that plan and was not even a party to the agreement of that plan. So there would be objections to that, those comments that talk about how he disregarded his legal restrictions when he was under none. And on page 6, again, it discusses that he continued to reside with Ms. Lopez at her apartment in spite of the orders under the CPS safety plan. She allowed him to live there. He was not residing there. In fact, at that time, that month, during that month or so before this event that he pled guilty to, he lived technically at his grandmother's, but he flip-flopped back and forth between his girlfriends, one being Jennifer Lopez, I guess you would call her co-defendant. She's charged with some matters associated with this, the mother of the child, and also another lady named Rashonda. So sometimes he would stay at Jennifer's, sometimes maybe a couple of nights in a row. But he would stay at Rashonda's more than that because they worked right next to each other and would ride together. So to say he lived in that house with those children is not correct, and we're moving to correct that as not being the truth. But more often than not, he was at Rashonda's, but he did stay at Jennifer's. And if both of those ladies were mad at him, he stayed at his house where he basically lived with his grandmother's. Again, in number 6, he's stating, on page 6, the third paragraph, non-compliance with legal orders, if that's referring to the CPS order, he was not under that order himself as a party to the order. And I believe those were the things that I wanted to correct as misleading information at this time. And like I said, there's a lot of information about other things that are being dismissed basically. And if I have missed one, I would request the opportunity to correct that and add that objection when the time arises.
Anything to say in response?
No, Judge. I do agree that he was not a party to the CPS safety plan. The safety plan was in place as a result of injuries that he caused to the child, but he has not pled guilty to those.
Okay, then the court will not consider those issues that were brought up by the defense.
That being said, Judge, it's undisputed that there was a CPS safety plan in place.
Okay. That's a fact. And what else?
It was a result of injuries that were alleged to have been committed by Mr. Bailey in Kevin Lane's case. That ends in 6/0, 2019, I believe. 19-33660. After that event, which was going to be dismissed, the safety plan was put in place, but he was not a party to that order, or even consulted in the order.
What else? Anything else?
No, other than the supplemental photos, if the court wants to consider them.
Well, submit them. And then
17.
Sure. You know which day this was?
November.
13. This one?
Everything is November after that.
This is November?
No, that's his case.
I know what it is. I'm just asking for the dates of these photographs. All of these are this date or this date? The ones,
All of those are
the
November.
rest of these are November?
Yeah,
Okay.
yeah.
I think they did that when we went back. Is that just supposed to be a closer up of that, or?
Yes.
9 and 10 are the same.
I tried to pick a couple of representative samples from each group.
And 11, basically the same. 3 is basically the same. 9, 10, and 11. Defense would object to states 1, 2, and 3. And 11. Fourteen. Sure, what person different ones? 14 and 16. 1 to 11. 1, 2, 3, I'm sorry. And 11. Just as repetitious as all. And 2 of them, 1, 2, and 3, because they're not related to this offense that he is pled guilty to. And the other numbers that I objected to just because of repetition.
What are the numbers again? I had 1, 2, 3. You said 10 and 11. What else?
I'll have to look. 14 and 16.
What's your response, Stan?
Judge, as you will note in the PSI,
What's the response, Stan?
as you will note in the PSI, the
You don't agree
prior,
with her?
no,
Okay.
the prior incident involving this defendant and this same young child were part of the investigation by the police in November of 2019. So while I understand why the court is limiting how it would consider that evidence, it is still information that was a part of this exact investigation, and also how the Port Arthur police eventually linked this defendant to the injuries caused to this
What
child.
was the other day you said?
September of 2019.
Yeah.
And
About
it's,
6 weeks before.
yes, sir, and it's already agreed that there was a CPS safety plan in place. It was all as a result of that prior incident. So while I understand that the court is not considering a plea of guilt, an admission of guilt in that prior offense, it is still part of the investigation, and that's why it's included in the PSI.
Okay, let me see.
And I would just add one last thing, Your Honor. On that note, the offense that is reflected in 1, 2, and 3, states 1, 2, and 3 occurs September 20th of 19. The offense that we pled guilty to is November 13th of 19. And he was indicted for that. He was not indicted on the injury to the child for the number 1, 2, and 3 until I thought I had my date right here.
Okay, anything else on the objections?
I didn't look specifically at the 10 and 11, Judge. Do you have those so I can, because it sounds like the objection to those is duplicate. they articulate different viewpoints of the same injuries. I tried to pick representative samples of the child's condition when he was brought into the emergency room in November of 2019. And each of these depict illustrates different injuries that were
Okay.
pertinent in the investigation.
All right, objections are sustained. So 1, 2, 3, 10, 11, 14, and 16 will be removed from consideration. And then that means states exhibits 4, 5, 6, 7, 8, 9, 12, 13, 15, 17 are admitted and are will be considered by the court for this hearing.
Okay.
What else?
All I had was those photos, Judge.
Any other objections from the defense?
No, Your Honor.
All right.
Yes.
Oh, okay. Anything else from the state?
No, sir.
All right, arguments,
Yes, sir. Okay.
beginning with defense, and then state can conclude. Go ahead.
So it's obvious, Your Honor, from the photographs that there are injuries to this child, and no child should be injured, and I would never say anything to want to minimize his conditions, or this the fact that he underwent injury, had to undergo injuries, especially the injury at the hand of the defendant, which we know from his admission of guilt was the abdomen. It caused some swelling to the intestines. What is good to know, and which is I would have to say, maybe by God's grace, that although the child went to the hospital with this serious bodily injury to his abdomen, that by the afternoon, he had already been showing signs of improvement. In fact, there are comments in the records about this child being life flighted to Houston, which would certainly encourage a person to think that this was a continuing serious bodily injury on through the evening. But in fact, he was transported by ground transport, the kangaroo team. So he went by ground transport. So if you see comments in the report about life flighting, that is an incorrect statement. Also, there were concerns of other issues that the child was having at the time, not just the abdomen and the intestines, concerns of liver failure and pancreatic failure. And luckily, by the end of the day, blood tests or whatever other testing that had to be done resulted in a finding that there were no signs of no findings to suggest organ disruptions. So although he definitely went there with an injury that was a serious bodily injury, rose to the level of a serious bodily injury. By the grace of God, it didn't continue on and started to heal already by the end of the day. In fact, there's a note in one of the medical records where by the end of the day or in the evening, when he's in Houston at that hospital, he is seen already, let's see, sitting up, playing with Play-Doh, and picking out a movie to watch. I'm not trying to minimize his injuries. I'm just trying to show that how thankful it is that they didn't, the seriousness didn't just keep on and on. He went in intensive care for 3 months. There's been children injured so badly, and these injuries the injury was serious, but thank goodness it began to, he got on the mend a lot quicker. In fact, he left the hospital, no prescriptions. He didn't have to have any surgeries. And so those are things about the injury itself that I feel like are important for the court to be aware of. As I said earlier, whether or not Jennifer Lopez let Kendrick Bailey know that he wasn't supposed to be around the children, I don't have anything that reflects that. I don't even think I found a statement from her, but that could have been something in the records that I overlooked. But I don't remember seeing anything where she said she ever let him know that he wasn't supposed to be around the kids. But he did stay there some, and he did stay at his other girlfriends, and at some points I'm sure he stayed at his own home. But he didn't intentionally go over there just to say, well, I'm not gonna follow that order. I'm just gonna go wherever I want to go. That wasn't what was going on at the time.
What was going on at the time?
Apparently,
you
he was
describe
staying
it?
with his girlfriend. And that was, and they
And
had,
quite naturally, he beats a child.
no, I'm not
I
saying
don't know
that.
what caused that.
He says in this, in his report, he tells the court that he just got carried away with correction,
That's not what I read.
And so, anyway, Your Honor,
That's not what the man says, but go ahead. It's a-
so, there's also, you'll see in those photographs, and I know that the state had an intent to submit the medical records. Those photographs are somewhat indicative. You'll see that this child had injuries of various stages, bruising of various stages. He lived in a house with, I'm sorry, I lost count. I know at least 8 kids. Sometimes there were up to 11 kids and 4 adults in a 2-bedroom apartment. This poor child was the littlest, and ages ranging, well, one younger than him maybe, and ages ranging all the way up. They all played together. There are records there are statements in the guardhouse tapes.
How many people were you seeing? How many? God bless
There
you.
were, at any given time, up to 4 adults and 8 or maybe sometimes 10 children, 10. And so
So what's the point of that?
the point is, sometimes you can get a bruise just playing. It's not every injury on this child has been at
This
the
is,
hand.
wait. This is
See-
serious bodily injury.
Yes, his abdomen was.
You said a bruise, but it's serious. There's a difference between, everybody gets bruises every day.
No, I'm talking about the photographs show bruising and different things.
Some of those photographs have been excluded.
I understand.
Okay, let's talk about just the one.
You'll see on the back, they're different there, and even in the records, it mentions there were injuries of various dates and times. So not every injury this poor child had is necessarily at the hand of this defendant. But that's why I'm pointing that out to you, is because I don't want you to think he was such a monster. He was just beating this guy day in, day out, and every injury he had. In fact, that morning, 2 of the children told the mother that the little boy had fallen out of the truck, and when they were all scrambling out to get out to school.
Where is that? I didn't read that.
It's
not
in
in
it's in the records.
It's not in there because
It's not in this.
it wasn't true, and that's why it wasn't in there.
Well, I never had anything that said it wasn't true. I only had it as though it were true. Nothing ever was given to me to indicate that it wasn't true, or I would not have repeated it as a lie.
If we're gonna talk about evidence, you're objecting.
Yes.
We're limiting things
Yes.
that are in this pre-sentence report that have been submitted by the state, which you say are outside of the scope of this matter. Well, aren't you doing the same thing right now?
Okay, I can tender the medical reports that talk about grand transport and not life flight. I can tender the
I
picking out
know
a
this is
movie.
outside information, but okay.
I have
that's
it
not in
here if, and the other diagnosis is of the child at the time that he was just
All right.
taken in.
That's-
But my point is to direct the court to the injuries to the child that were the injury to the child, to the abdomen, which causes intestinal swelling, was serious bodily injury. And thank goodness, by the end of the day, which if I can tender these reports, he was already on the mend. And I'm hoping that the court will ultimately recognize that, like I said, really, I'm sure his injuries could have been much worse and maybe not healed as fast. And that doesn't lessen them, but it might mitigate the length of sentence that the court is suggesting might sentence this man to. He would ask the court to grant probation. He's not expecting probation. He didn't even think the court would give him probation. I've never told him to expect that, but I am trying to help him maybe
Why would you say
minimize.
that?
Huh?
Why would you say that? It's an option. for the
It certainly
court.
is an
So
option.
why are you
Just
telling
because-
him that's foreclosed?
I didn't tell him it was, did I ever tell you that there was no way you were gonna get?
You just
probation?
said you said the court wouldn't. do
Not
it.
to expect it. I said not to
Why
expect it.
not?
because this is a serious bodily injury case on a child and a 25-year cap. And I just, am telling him not to get his hopes up for something that may not happen. That's no good. That's not doing him any
Every
good.
cap is a may not.
That's right. And I discussed that with him. I would suggest that, and let me just double check before I close, please. I would point out that in the criminal history, the 2009 evading detention, it says it was a deferred prosecution under the juvenile system. And he doesn't really remember what all he might
It's
have had to
not,
do with it.
that won't be considered.
But then you'll notice that the next thing is almost, let's see, 2009, almost 10 years. 9 years later, he has an assault that he is accused of. It was dismissed. And then all of these occur. So where in the pre-sentence report that it says that based upon his defendant's history of non-compliance with criminal orders, his criminal background, collectively caution against probation, we would say that the criminal history is not that egregious. And if the court were willing to grant him probation, he would ask the court to do that, to grant him probation. But that his history indicates a long-standing pattern of criminal behavior and substance abuse. He's got a couple of drug cases when he was a juvenile and a dismissed adult family assault. I don't see that necessarily there's a long-standing pattern of criminal behavior in all of these cases at one time, right in the same time period. Maybe that's what led the probation officer to use that phrase. But we would say he doesn't have necessarily a long-standing pattern of criminal behavior based upon the pre-sentence report records. And the severity and repetitive nature of the defendant's offenses, I'm not seeing that in the pre-sentence report based upon the records of his criminal history. Combined with his demonstrated disregard for legal and protective measures, which he was not under an order to abide by, suggests a more stringent custodial sentence might be necessary to ensure. And so we would suggest to the court that all those things that were believed to maybe be true, for example, life flighting and the seriousness that really didn't happen, we would ask the court to consider that his minimal criminal history as a juvenile and minimal criminal history as an adult, along with the suggestions that he had violated a court order which he wasn't under. That in light of all of that, we would ask the court to consider probation. And if not, I would ask the court to consider something around in the 10-year range on this case. Thank goodness he was most ill on that first day. And I think that that indicates that although serious, it wasn't an extended length of time that he was under the weight of a serious bodily injury.
What do you have to say, sir, if anything?
Just want to apologize for what had happened on that day. I take full responsibility of it.
What happened?
I just gave him a whipping. It wasn't beating. I disciplined him. I took it a little overboard. Under the drug. Because I was under the influence of marijuana.
Sir?
I was under the influence of marijuana. And I just want to apologize.
Where did the marijuana come from?
We said where it come from?
Yeah, where do you get your drugs? You don't want to answer that?
Like, you mean the person?
Yeah.
I don't know his name.
Well,
It
tell
just
me
be
how that
multiple
happens.
people
Tell me how do you get drugs?
off the streets,
How do you do that?
just ask around. I never just asked their names or nothing like that.
And drug usage was the cause of this?
I could say it played a role in it.
What else played a role?
My anger, which I got control of since I've been incarcerated. I've been learning how to cope with it.
Well, you're in a confined facility, you're in a secure facility. This isn't the free world.
There's a lot of things that go on in Jefferson County.
Unless it makes it seem as long as you're confined, you're safe to others.
I wouldn't fully say that. Cause I feel as though I've become a better person. And that's why I'm asking for the opportunity with a second chance
What are you sorry about? You said you're sorry.
for the injury that I committed.
What was the injury?
For the abuse
What did you
of
do?
the child.
What did you do? How did you do this?
I whooped him with a belt. And I tapped him with my hands.
Tap? You're
I didn't
calling this
punch
a
him or
tap?
nothing, but
Okay. And this is true, you were under some kind of a protective order at the time, is that right?
I
No.
didn't know nothing about that.
You did,
So from my understanding, it's no,
on a previous event involving this child?
no, sir.
So there was never, do you know what we're talking about, a previous event? In
Kevin's
In
case.
Kevin Lang's case. Yeah, I
In
never
Mr.
knew
Lang's
nothing about it.
case?
I
I mean-
never knew nothing about a protective order. Nobody
Well-
told me nothing about a protective order.
You're familiar with what that charge is all about, though, right?
Yes, sir.
Okay. What happened to the child there? Was the child treated in the hospital or anything? I mean, the
think so.
child, you live in that household, right?
I don't stay there.
Your Honor, I
And
would,
around that time.
At that
happened,
time. At
When that
that time.
happened, I was at work. And after that, I didn't go to her house for almost a month.
Okay, the child, it looked like had some serious injuries here on that earlier occasion, right?
Your Honor, I'm object to the court's consideration of the facts in that case, which is extraneous to the sentencing here and will be dismissed as part of the agreement if the court follows it.
Again, I will respond that the court is going through the exact same logic that Port Arthur investigators went through when they were investigating the November 2019 injury at the hospital.
Yeah, I'm curious about what notice or information or what this defendant knew from an earlier investigation that may have resulted in what happened here. But the fact of the matter is it was an indictment that was handed up, and he had to have been charged officially and arrested and booked in, and so he's aware something.
I got
But
arrested.
what's the time period that this earlier event occurred?
September 2019,
Which
And-
was how long? 6 weeks? 8
about
weeks?
9 weeks, Judge.
And when he was arrested on this case is when the investigators started talking more about what had happened a month
Are you-
before, but he had not been arrested on that.
Are you aware of who caused those injuries on that earlier event?
No, sir.
Okay. Do you care to know?
Yes,
How
sir.
is the child related to you again?
He's not.
He's not even related to you? But you were in the household, right?
Yes, sir. I was dating his mother.
Okay. You didn't care to find out what might have caused that?
All I know is she texted me while I was at work saying he was injured. She took him to the hospital. She ain't talked to me for a month. Then in that month, she called me and told me to come over.
Okay. What else?
Sir,
Anything else you want to add?
no, sir.
Are you, may I ask him a couple questions?
Go ahead.
Since you've been in jail for this time period waiting to come to court, which I believe you were arrested on the date of the offense, alleged, in in 37868. So you've been in jail since November 13th of 19,
Yes, sir.
and in that time period.
So-
Hang on one second. Has he been sworn?
No.
Do you want to?
Raise your right hand. Do you solemnly swear or affirm any statements you make today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. Go ahead.
And I'm just gonna ask you this because I know you mentioned it to me when we were in our discussions that during this time period, you recognize the type of lifestyle you were living back when this occurred. And it was mostly kind of running the streets and doing whatever you wanted to do.
Yes, sir.
You worked a little bit,
Yes, sir. A lot.
and since you've been, but you didn't finish your education.
No,
And since you've been in jail, what has been your thoughts about how you would like to live the rest of your life?
I want to get my GED. I want to take the CDL classes to get my CDL, and also I want to do what's it called? Selling houses, real estate. I've been looking online, well, on the tablets we have now. I've been doing, I've been taking little courses for stocks and bonds, and for the and I'm trying to get the one for the real estate. I just found out that they got.
So regardless of what sentence you get, whether it's time in prison or it's probation, you have plans to work on the way you live your life when you get out?
To better myself.
Or while on probation or after a sentence, and
Yes, ma'am.
that's all.
State.
May I ask questions, Judge?
Yeah, you may.
The child in this case, Jeremiah Williams, you called him BJ, didn't you? Or everybody called him BJ?
That was his name.
Okay.
What
who's-
did BJ stand for?
Baby J, I think. Baby Jeremiah, something like that. I just called him BJ.
He was like 4 years old.
Think so.
Who was BJ's father?
Jeremiah Williams.
Do you know Jeremiah Williams Senior?
Yes, sir.
What's your relationship like with Jeremiah Williams Senior?
I mean, he didn't like me. David's children's mother.
You've had a number of altercations with Jeremiah Williams Senior, haven't you?
In Jefferson County, because he spit on me.
And outside Jefferson County too?
Yes, sir.
And when you were talking about Jefferson County, you mean the jail?
Yes, sir.
And what about, did you like him, Jeremiah Williams Senior?
I mean, I didn't have a problem with him.
Even though he didn't like you and attacked you and spit on you?
Still didn't have a problem with him.
The morning of November 13th, when you took the kids to school,
Mhm.
why did you want the truck?
Because I had something to do.
What'd you have to do?
I can't remember.
So if other witnesses had told us that you had some licks to go hit, would that be true or not true?
I don't understand the reason of that with dealing with this case.
You took all the kids to school that morning, right?
Yes, sir.
You dropped the older kids off at Travis Elementary, right?
Yes, sir.
You dropped Jeremiah off, didn't you?
Yes, sir.
But you dropped Jeremiah off 3 hours later, didn't you?
Yes, sir.
So Jeremiah didn't get to school on time.
No, sir.
What happened in those 3 hours?
We already came to the conclusion of that.
What'd you say?
We came to the conclusion of that.
Answer the
That I
question.
disciplined him.
What did he do to deserve discipline?
Just crying for no reason.
For no reason whatsoever. And where did you discipline him at? Where were you physically at?
In the truck.
So you and Jeremiah stayed at that truck for 3 hours.
No, not 3 hours. I had to drop the daughter off. Then I had to go do what I had to do. But it wasn't no 3 hours. I was disciplined. You can't discipline nobody for 3 whole hours.
Well, how long did this thing that you don't remember you had to do, how long did that take?
About an hour.
Okay. And you're saying here today that was not a drug deal.
Refuse to answer.
Move on.
And you said that you hit Jeremiah with a belt?
Yes, sir.
You never hit Jeremiah with your hand?
Yes, sir.
Did you
I
hit,
didn't punch him. I never punched him.
you never hit Jeremiah with a closed fist?
No, sir.
Did you sit on Jeremiah?
No, sir.
He's not alleged to have sat on him in this case. Speak to that.
That manner and means is causing abdominal injury.
No, sir. I never said on.
Nothing further, Judge.
Okay, go ahead, state. Your turn.
Judge, okay, so I have a few things that I do need to correct from what was represented to you earlier. First, the kangaroo team at Medical Center, that is, or at Texas Children's, that is actually a more advanced team than Life Flight. That team includes specialized nurse practitioners, emergency medical services, and they come as an entire group of people only in specialized cases where there is either serious injury or death at risk. That the kangaroo team from Texas Children had actually probably only comes to Beaumont once every couple of years. This is not something that is, oh, well, he wasn't life flighted by a helicopter. So he didn't have as serious of injuries as it appears in all the photographs, all the medical reports and everything else. This child, when he presented at the emergency center in Beaumont, he was in multiple organ failure. And that is clear by the blood levels for his liver enzymes. And as the court is aware, the injuries alleged here are abdominal intestinal swelling. That is part of the digestive system, which is also the liver, which also affects pancreatic function. That is the reason why those two organs were in failure. And I wholeheartedly disagree with the representations that this kid got on the mend later. He was at Texas Children's for 5 days. This is not something that was just an easy thing to get on the mend from. The other thing that I have a problem with is that these types of injuries are internal. And the whole issue here, Judge, is that the abdominal injuries, what you'll see in the photographs, there are injuries to this bruising to this child here and at the lower pelvic region. Those types of injuries can only be caused by severe force. Hitting someone with a hand, hitting someone with a belt is not enough force to actually cause injuries to the abdomen in that way. This was serious force. And for that, I think that he is still not being honest with the court about what he did or how it happened. And I have a very serious problem with that.
You know what?
Oh, my bad. I'm sorry. I'm sorry.
Let him,
Yes, sir.
number one, he is entitled to speak just like you were.
Yes, sir.
Besides, interrupting like that's rude.
Yes,
Go ahead, finish.
He claims he's being honest, but he won't tell us where he was on this mysterious trip that he had to go to the morning that he took all these children to the school. And I mean, that's when the injuries happen, Judge.
Anything else?
Judge, are we asking for as far as what our recommendations are? I think mine are clear. This is,
Anything else before everybody gives their final request to me. Let me, I want to clear one thing up. This previous CPS order that had been entered into at the time that the defendant committed this crime, did it order the defendant not to have any contact with children?
he was not a party to the order.
Okay.
It was Jennifer Lopez, the child's mother, that was the party to the order. So that is by virtue of her disregarding that order, that is how she has a case pending.
Says in the pre-sentence report, despite a CPS order prohibiting the defendant to have contact with children, he was living with them. That's obviously misleading.
Correct, Judge. I do agree that that is not orders expressly prohibiting
Okay.
him. I will say that we intended to present evidence, and I don't know if it's encompassed in the reports that he knew of the order.
But the order would be prohibiting him in personally. Does he know that or not?
The order prohibited her from allowing the children to be with him, but he was never made a part of the order. He was never talked to by CPS. He was never served with anything
All right.
and never signed
All right,
anything.
that's all I need to know. But summarize, what do y'all want?
Again, Your Honor, he has been in jail for quite some time now. We're fortunate that the child's injuries, although initially serious, that he was able to overcome them even after 4 or 5 days, as the state said, that he left the hospital without even a prescription or a surgery or anything. The defendant has had plenty of time to think about his life going forward. He asked the court first, he would ask the court to consider a probation with all the regular terms or whatever terms the court felt necessary. And in the alternative, I would ask the court to consider that although 25 years is not 99 years or life, it is our cap. And I would say that even within the cap, that the court, we would ask the court to consider something around the 10-year range if probation is not appropriate.
Judge,
State.
I'm deeply disturbed by his version in the PSI. And then, in my opinion, he just made it worse today by what he has proffered to the court as far as like trying to explain how all this happened. This is worth every penny of the cap of 25. I would ask for 25 years.
Anything else, Mr. Bailey, you would like to say?
No, sir.
All right. So in this case, the evidence is before the court, the pre-sentence report with its limitations have been placed into the record. This defendant, Kendrick Deshaun Bailey, earlier pleaded guilty to this first-degree felony of injury to a child here in cause number 21-37868. He has done this voluntarily, knowingly, intelligently. There was sufficient evidence supporting his guilty plea from State's Exhibit 1 here that was admitted into evidence to find him guilty beyond a reasonable doubt. Before I make my findings and determinations, I'm going to ask you one final thing, Mr. Bailey, your relationship to Jeremiah, who was the child who was injured here. What is your relationship? I mean, how do you, what was your relationship with him at that time?
What do you mean, y'all?
What was
Family
what was
relationship, what is your
was he
relationship?
just a passing person, or was he close to? Were you close to the child, or what? You know anything?
Like, no, I really wasn't around like that.
Huh?
I really wasn't around like this, so I couldn't just say like we was close.
Okay.
But I was,
What was your relationship to the child's mother?
we was just dating here and there.
Just casual dating?
Yes, sir.
Okay. And the child, how old was the child at the time?
Then 4.
Okay. Anything else you want to add?
Yes, sir.
All right. The court is going to point out what this court feels like are the substantially significant aspects of this case from the pre-sentence report. The child was not 4, he was 3.5. The child was 3.5 years of age at the time. And he was received by the emergency room in critical condition. And the examinations by the hospital team revealed severe injuries, including bruising to his face, ears, chest, back extremities, abdomen, and pelvic area, as well as laceration under his chin that we see in some of the exhibits that were admitted. Were these exhibits from the earlier?
No, all of
This
those are
is
from
Or
the,
this one?
yes, sir.
Okay, I think the chin is state's exhibit. 8. 8 shows the chin child, but we see in state's exhibit 6 numerous bruising to the legs, bruising in state's exhibit 7 to the face, laceration directly under the chin, bruising to the back of the child, bruising to the upper thigh of the child, bruising to the chest area of the child in these exhibits, state exhibits that were admitted. The X-rays revealed multiple rib fractures. CT scan showed bowel wall thickening and potential internal bleeding. Blood work indicated multiple organ failure. The liver enzymes, which are normally 20 to 30, were shown in the testing of the child to be over 5,000, which was suggesting liver failure and signs of pancreatic failure due to the child's injuries. These findings necessitated his transfer to the Texas Children's Hospital for specialized care. And I think it was a life flight, wasn't it? That was none of.
It was
a helicopter.
kangaroo team.
It was ground transport, Your Honor. It was not life flight. And that's
Was
what you
he-
just asked. I'm answering. It
Was he
not-
transported to the Texas
by
Children's
ground,
Hospital?
Not,
Okay.
not a helicopter.
Somehow he
and-
was transported by by emergency
Yes.
medical team. Okay.
And we are, before you move forward, when you mentioned that it revealed multiple rib fractures, I would like to, I don't know if you noticed, but it said they were healing rib fractures. They weren't from that day. They were healing rib fractures, if you will. That's all I had to add.
The child was injured and was healing from rib fractures, and then he had to suffer this assault subsequent to the original rib fractures that weren't even healed yet.
That's correct, Judge.
All right.
We don't have where they came. Yes,
I'm sorry, what did you just say?
I withdraw.
What did you just say?
I'll withdraw my comment.
What was it? So we
No,
can
I
know.
don't want to cause a problem, so I'm not going to repeat it. Please. Your
Well,
Honor.
what I want is accuracy in the record. You
There
want to say
are-
that? Something?
There are different indictments, all with different rib fractures. There have been records of rib fractures of different healing stages. They're not known to be attributed to this defendant, and so I just was pointing out that instead of it just revealed multiple rib fractures, as the court stated, which could indicate they were all fresh, these were different injuries as this child had.
The point the court's trying to make is that the child was, that's now been clear, the child was recuperating from injuries previously, and now he suffers more injuries to the area where those, to the stomach area where those injuries had previously occurred and were healing.
Correct, Judge.
Yes, sir.
According to this pre-sentence report, the child stated that the defendant is mean and he hurt me. The child stated that the defendant would take him off his bed at night when the siblings were asleep and place him in the closet or hall and sit on him.
Again, those would be extraneous things that I don't believe have ever been tested.
It's child statements that were made at the time of this report concerning his relationship with the defendant. He also demonstrated how the defendant hit him. The defendant's version. I don't even really know what happened that day. Honestly, I was high. And he, I guess the child, probably just ticked me off. I just took the discipline a little overboard. Let me ask you, what authority do you have to discipline this child in any way?
None, Your Honor.
None, not a thing. All right. You have pleaded guilty here to seriously causing, intentionally and knowingly causing serious bodily injury to a child not older than 14 years of age. In this event, the child was 3.5 years of age. Serious bodily injury was caused by you. Serious bodily injury is defined in the Penal Code as bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. I think you would have to agree that's very disturbing for injuries to a 3.5-year-old. Life-threatening is what we call that, right? The statement of interested party, this was used in the pre-sentence report.
This is Jeremiah's adoptive mother. She is the person who worked for Jeremiah's was Jeremiah's biological mother supervisor at the time of these offenses and cared for Jeremiah and then adopted him.
Okay. Is she here?
She's
By any
not.
chance?
She's
Oh, okay.
she's with Jeremiah,
All right.
but she has been instrumental throughout this case in helping obtain medical records and everything else. She's a very good person.
I've objected to this kind of recitations, Your Honor, characterizing the person who wrote this. Qualifying for person.
Once again,
character.
I'm not gonna, I don't, if they're not here, I'm not gonna consider this for the purpose. of-
Right. That's a statement of interested parties that is normally within the PSI. She just didn't
A
get
lot
it
of
to-
times people are here and that is where they can be placed under oath and then cross-examined.
Sure.
If nothing further, I'm going to find as follows. That you, Mr. Bailey, have pleaded guilty voluntarily, knowingly, intelligently. There was, again, evidence supporting your guilty plea from State's Exhibit 1 admitted at this hearing to find you guilty beyond a reasonable doubt. After considering the pre-sentence report, listening to additional evidence, arguments of counsel, and statements you have made, I hereby find you guilty beyond a reasonable doubt of this first-degree felony of the most disturbing type of case, one of the most disturbing types of cases, and that is intentionally and knowingly causing bodily injury to a 3.5-year-old. And here by applying blunt force trauma to the child's abdomen area. I hereby find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 25 years. 3.5-year-old child should be thinking more about Santa Claus and fuzzy little animals and the good things of life, not having to live through the horrors of what a cold-hearted person, adult, can do to a 3.5-year-old child like you did. You took advantage of an innocent child, one of God's greatest creations and gifts to all of us, and you almost killed the child. According to the definition of serious bodily injury. That is all. We're in recess.
I've submitted dismissals, Judge.
All right.
So Christmas is coming early this year. We're going to check that list when it go up on that wall for voting, and we're going to check it twice. And we're going to find out who's been naughty or nice based on how y'all vote. And we're going to start it off with Maria Haddon. Yeah.
Chicago and some communities so angry? Why is all this kind of anti-immigrant sentiment coming up? And I want to explain to folks, it's because if we cared as much about black people and had over the decades as we do about everyone else, we wouldn't be here. But the money from a 2020.
All right. That would be Maria Haddon. Stepping out there, I see you. Don't get sarcastic because we can get jiggy, right? You set up here for that first 51 million talking about how you feel about black people and how you have to have the same energy for black people, and you ain't never stood on this floor talking about money for black people. You get on this floor and talk about black and brown because you somewhere in the middle with it, right? But I'll tell you this, and I'm telling every other black alderman in here today, you vote for the money for these immigrants today, and we coming for them seats. You can believe that. You're going to stop pimping the black people's plight to get brown people, as y'all call it, money. You're going to give us our press conference up there on the 3rd floor, keep talking to the mayor's boy with the clink clink from his past. That's why he got to do what the mayor say do. Him and a lot of other ones in here with these shady pasts. That's why you got to vote the way that you vote. But all of us ain't got shady passes. Some of us free out here, and we can vote how we want to vote, and we coming for those seats. Now, to align yourself with somebody who's obviously a one-term mayor, if he even makes it that far, you better be worrying about your job. You better be worrying about your longevity, because we're going to vote, and we're going to get you out, because you ain't doing right by us. That's what time it is. And for your law person that's next to you, I'm going to need you to check out that federal charge that I got against those public administrators over there for messing with black people's property. It's federal case number 23CV14590. All right? And on that note, if y'all don't give us our money for the black community, know this, we getting ready to file a federal injunction against City Hall for benign neglect to the south side and west side. You got that? Boom.
We keep it working like Oouchie the boss. We tryna catch up like we hit us a fault. We gotta win, ain't taking no loss.